Okay, good evening, everyone. We're going to go ahead and get started. Welcome to the first quarter Georgia Arborist Association webinar, Trees and the Law 1.0. For those of you who don't know me, my name is Jessie McClellan, and I am the new Executive Director of the Georgia Arborist Association. Today is day 2 for me, so if there are any issues with this webinar, I do apologize. I hope you'll give me some grace as I step into this new position. Welcome to Trees and Law 1.0. This is a 2-part series. We hosted the 2.0 previously. At the end of this Zoom, by the end of the week, I will be sending out a recording of this webinar, so you'll have that to review, and you'll also receive a copy of the 2.0. We do welcome your Q&A during the webinar. So if you do have questions for Lee, please feel free to drop those into the Q&A portion of Zoom. Don't put them in the chat, just put them in the Q&A. And I'll be monitoring those throughout and interrupting Lee as necessary. And there is a CU opportunity for this training session. At the very end of the session, I will be dropping that link into the chat. So please keep an eye out for that in the chat. There'll be a little survey to fill out for you to put in your credentials, and we'll go ahead and submit that to the ISA at the end. If you have any questions for me throughout, please feel free to send me a chat, and I'll be monitoring that as well. We're going to go ahead and get started. Lee is our presenter tonight, Lee Clark. Lee has worked as a paralegal, a criminal defense lawyer, and a college professor. After getting a master's in forestry from UGA, she is now with the Georgia Forestry Commission and serves as the community forester for Northeast Georgia with 43 counties in her territory. Her focus is on providing support for cities, counties, and tree advocacy groups to improve their urban tree canopy. And I am going to go ahead and stop sharing my screen, and I'm going to send it over to Lee. Welcome, Lee, and thank you for joining us this evening.
Thank you, Jessie. It's good to see you.
Good to see you as well.
And let's see. Here we go. I'm sharing.
I can hear Lee just fine. If everybody else can hear her, we'll carry on. If not, please say something in the chat.
Okay. This is, as Jessie said, this is Trees in Georgia Law 1.0, or this is, well, you know what I did? Pulled up the wrong one. This is Trees in the Law 1.0. As Jessie said, there is a 2.0 version, which I briefly flashed on the screen. 1.0 was the first one that was conceived, and it was kind of just an overview. It talks about, well, we'll go into the topics. These are the topics. It talks about nuisance and negligence. We go through standard of care, what it is and who owes it. Boundary trees versus non-boundary trees, that all goes into the discussion of who owes the duty of care. And then we cover a few of Georgia case law, a few of the cases, and then the timber theft statute in Georgia. The 2.0 Trees in the Law version that Jessie referred to is more of a deep dive into the case law. It's just case law, and we go through the chronology of it, how it started, how it developed, and where it stands now. So it's a little bit more of a deep dive than this is. This is an overview. So thank you for joining. This is a little bit about me. I am, as Jessie said, a community forester with the Georgia Forestry Commission. I'm ISA certified and also track qualified. I have an MFR from Warnell, and in my previous life, I was an attorney. I'm still a Florida bar member, but I'm inactive, so this is not legal advice what I'm giving you, and I'm also not even licensed in Georgia, so I couldn't do that anyway. So what we're going to cover is there are many broad areas of the law that involve trees. We're going to really narrow it down. There are lots of things that could be covered, and all these are really important topics in our profession. Arborist liability, for the corporation or the company that the arborist works for, as well as personal liability. That's important, but we can't cover that tonight. The valuation of removed or damaged trees, I get calls for that all the time, probably every week, somebody wanting to know about that. That's a whole different topic we can cover. Who gets to keep the fruit? This is a big topic out in the West where fruit trees and nut trees are cash crops, much more than they are here. Then we've got planted timber and rural issues, municipal and utility liability, and then view obstruction cases come up under the heading of tree law. We're not going to cover any of those. What we are going to cover is at the bottom. It's
Haley,
yes.
we're still seeing the 2.0. Would you mind stopping sharing your screen and switching back to 1.0?
Well, my goodness, yes. Let me do.
Sorry to interrupt.
No, you should interrupt. How do I stop the share? It says new share. It's giving me, oh, stop share.
There you go.
Well, I was just blabbering on. Okay. Okay. Okay, is that shared? Do you see the intro?
I'm just seeing you right now.
Oh, okay. Right. Share.
Okay, that still says 2.0.
I know how to fix this.
There we go. Now we're working.
All right. So
thank you everyone for your patience. Carry on.
Sorry, that's totally my fault. Okay, so here's the topics that I just kind of went through: nuisance and negligence, standard of care, duty of care, what it is, who owes it, and how you determine that is by determining that you have a boundary tree or a non-boundary tree. And then a couple of Georgia cases and the timber theft statute. This is a little bit about me. I already went through this. It's not legal advice. Okay, here are areas of law that involve trees. I already read through these. I'm so sorry that I was just talking into space and y'all were not seeing this. So that's a quick overview of what I just read. Here we are. Okay, so negligence, tree law is a civil liability issue. It's usually not criminal charges. There can, of course, be extreme situations that can result in criminal charges, but most of what you're going to see is a civil lawsuit and between neighbors or someone who was injured by someone's tree. And the civil lawsuits can be based in either negligence or nuisance. Those are different cause of actions. Those are different things that a person could sue someone else for. Nuisance is really a failure to act reasonably, and I'll go through the elements of that on the next screen. Negligence is the same thing. And you'll see in this, and I highlight the word reasonably because all throughout the area of tree law and really law in general and in contract law especially, it all comes down to reasonableness. And so I highlight through this throughout. So you can see when you can't figure something out, you just think about what would be reasonable. What would a judge or jury think is reasonable? So going through nuisance, if you want to sue a neighbor for nuisance or someone's being sued for nuisance over a tree issue, then what has to be determined, what the judge or the jury has to determine is that the tree was a hazard to start with. And so you're going to need an arborist opinion and probably arborist testimony to establish that. Did the hazard persist? And that's going to answer things, or that will address things like how long was the condition like that? How reasonable was it that the owner could have mitigated that hazard pretty quickly versus putting it off? And did the owner act unreasonably in what happened? And then the harm followed. So it all comes down to the owner acting unreasonably by allowing this hazard to persist. Nuisance versus negligence. Nuisance is not used very often. It can be, it's out there as a cause of action, but negligence is so much easier and it's so much more common that really most lawyers are just going to default to negligence, which is what they know. Negligence is all these commercials you see on TV of the lawyers that are doing car accident cases. This is negligence. Negligence has these elements. The most common kind of negligence case is car accidents and injuries that come from them. But tree law applies the same way. You know, harm happens and somebody or something is damaged. So negligence has these four elements. They're all based, as I said, in reasonableness. One is a duty. We'll go through each of these elements separately, but we spend quite a while on duty. Then breach of that duty. So you have to determine what the duty was and that it was breached, that there is proximate causation between the breach of duty and the harm that happened. And then damages, as it's used in the law, means both the harm that happened and then the money that can be paid as a result of the lawsuit to make the person whole again. Damages refers to both the harm and the money. So here is more details about the negligence for elements. We've got to figure out under duty, we have to figure out who has the duty. Well, the owner of the tree has the duty. So now you have to break that down farther and get into who owns the tree is dependent on where the tree is located. If it's totally on one parcel, that's great. If it's a boundary tree, you got some figuring to do. So once you determine who has the duty, then what is it? And really the question of what is the duty is just asking what would have been reasonable in that situation. Then you get into breach of duty. You have to establish that there was an unreasonable action by the person with the duty, that they acted unreasonably. They didn't inspect the tree, or they saw that the tree was rotten and they didn't do anything about it, would be an example. Then causation, it has to the breach of duty has to proximately cause that harm. And proximate is kind of a wiggly legal word, but it means that it has to be direct enough that it's traceable, and that it's not just some far way crazy later conclusion that really wasn't foreseeable. Then damages is both the harm that happened and then the money that's awarded afterwards. So duty, we go through each of these elements. We spend a little while on duty because we've got to go through the boundary trees and the owner of the tree issue. So with the first element, duty, two questions: who owes the duty? Well, the owner of the tree. Well, who's the owner? Depends on where the tree is located. So is this a boundary tree or not? If the tree started on one parcel, but then over time it expanded and it grew into an adjoining parcel, well, it depends. States do it differently. In some states, it becomes a boundary tree. Didn't start off as one, but it can grow into a boundary tree. And so then both landowners, property owners, would own that tree and have rights to it and responsibilities. In some states, since it started only on one parcel, then it just stays with that same owner, even though it expanded over. The original owner is still responsible for it. In some states, it depends on the conduct of both of the landowners that share the tree. Do they treat it like a boundary tree? Do they both take care of it? Do they both garden around it? Do they both prune it? Do they both comment on it and use it and enjoy it? Do they treat it like a boundary tree is really what they're going to look at on the conduct of the property owners. Non-boundary trees are really easy. These are the ones that are clearly on just one parcel, and you don't have to worry about boundaries and property lines and all that. Those are the easy ones. So when you have a non-boundary tree, you've got encroachment issues come up a lot as an issue, even though you know that it's your neighbor's tree. I get calls. I just got one this week, actually two this week, about a non-boundary tree with root encroachment issues. So it can be branches overhanging, it can be fruit falling if that's undesirable. Roots cause a lot of damage, driveways, sidewalks, foundations of houses, even other trees can be disturbed by roots. We all know root damage. And there can also be imminent potential for harm if the tree is not sound or not healthy and it looks hazardous. So some of the encroachment issues with non-boundary trees, don't do what's in the picture. Don't take it, don't advise anyone to do this, and really discourage your clients and neighbors from doing things like this, because that's very harmful for the tree. And yeah, don't do that. So what can the neighbor do? Well, they can cut the part of the tree that crosses onto their property, but there are limitations on that. And again, it all goes back to what's reasonable in that situation. They can't trespass over the property line in order to cut the tree. They can't cut over the property line, and they can't permanently damage the tree. That's a hard concept. Cutting roots, that's going to damage it, but is it permanent damage? Cutting branches depends on how big the branches are and how main they are. Arborists need to get involved with this, and professional opinions need to be rendered. The best idea when it goes in the best case scenario is when the neighbors talk to each other and just come to an agreement about it. So going back, when you have a boundary tree, and we're still trying to figure out, is it a boundary tree or not, because we're trying to figure out who owns the tree, and the owner of the tree is the one with this duty. So we're still figuring out who owns this tree. Well, with a boundary tree, if the tree is on more than one parcel, then both of those property owners own it equally, as this legal concept called tenants in common. There's different kinds of tenancy, but tenants in common means that they're both responsible for the maintenance and care. They're both responsible for what's on their side, but they're also both responsible for the tree as a whole. So whatever they do on their side can't damage the tree as a whole, because they own the whole tree, but they share that ownership. They're tenants in common, so they share the tree equally. They have joint liability if the tree were to fall or injure someone or cause some damage. Then they both have liability because they both own that tree. If the tree is healthy, then both of the owners have to agree to remove it. If the tree, well, there is the exception about the tree interfering with one owner's reasonable use of their property. I see this come up most often with roots growing under a driveway or a sidewalk. That gets stickier. That means you need to call in lawyers and really figure this stuff out. But if the tree is not healthy, if it's unsound, if it's hazardous, or it's any kind of a risk, then you don't need the other owner's permission, because the law sees that you remove this hazard, you're actually conferring a benefit rather than taking property or resulting in a loss. But of course, all of this needs to be backed up by expert opinions. That certified arborist in writing is the best. And then if it gets to a trial, then it would be best, of course, if that arborist were to testify. Probably wouldn't get to a trial though, but. So circling back around to duty, we're back on the elements. So we've got the duty is a standard of care, which really is just what would a reasonable person do in that situation. There's always under the law, in every situation, tree law or not, a duty to act reasonably. When we drive our cars down the street, we have a duty to act reasonably to the traffic around us. And that's why negligence is the basis for all of the car auto accident cases. There's no specific duty when you're dealing with urban trees. There's no specific duty to inspect urban trees. Like, you're not on a monthly or yearly schedule to go inspect all the trees in your yard. The law would not ask that of you, but the totality of the circumstances matters. Any kind of tree law case where there's damage caused by a tree, they're going to look at all the circumstances, what you knew, when you knew it, what it was, how long it existed, and everything that is feeding into the tree's condition and the circumstances around it, and then the damage that it did. Property owners and tree owners cannot ignore obvious clues. They can't just say, oh, I didn't see that, or I'm just going to say I'm not an arborist, so I don't know what that means, because we all have common sense. So again, it just goes back to reasonableness. So knowledge under the law, if you know that the tree is hazardous, knowledge can be actual knowledge or constructive knowledge. Actual is that's what we think of when we really think about, I know something. It means you actually know it. You learned it by seeing it yourself, or an arborist told you, or a neighbor came over and knocked on your door and said, hey, you need to look at that tree, or a tenant did the same thing. That's actual knowledge. You really know. Yeah.
We have a question in our Q&A. If you don't mind taking your first question. The question.
Yeah, go right ahead.
Okay. The question is hazard versus risk. Do you differentiate between the two? That is, are there differing legal ramifications for the use of either word? Are the words used interchangeably in this context? A hazard seems to have a stronger connotation.
Hazard and risk are not legal concepts as I'm using them here. They're not in any of the case law. They're not defined, and the cases are not about the definition of hazard or risk. And I'm not using them in a legal context here, and I am using them interchangeably. I just mean that Well, as we flesh this out, we can circle back to this question, but I think as we flesh this out and you see what the case law requires, what the standard is of decay and knowledge and the inspection duty, you'll see that they are interchangeable and how I'm using them. So I hope I answered part of that, but I think at the end, bring that up again and we'll see if we can circle if I haven't covered that by the end. But thanks, Jesse. Yeah. Let's see. Okay, so we were talking about constructive knowledge. That's knowledge that you don't actually have, but that the law says you really should have, because a reasonable person in these circumstances wouldn't have this knowledge. They would know this. So the clues that you can't ignore are fungal fruiting bodies, leaf decline, just the overall appearance of the tree, visible wounds, huge cankers, anything that a reasonable person could look at that and think, that's probably not a good sign on a tree. So those are the two kinds of knowledge, and that's all still under duty. So with duty, you figure out who owes a duty, the owner of the tree. What is the duty? Well, it's to act reasonably. And knowledge, needing to know knowledge, comes into acting reasonably. If you have knowledge of a hazard, yeah, you got to mitigate it. We'll see that as the cases, as we go through the cases. So here is what I call somewhat recent summary of a good on-point case. It's from 2015, which might seem like a while ago, but in court time, that's really not that long ago. This is a mid-case appeal, an interlocutory appeal. And so it went up on appeal while the case was still progressing down in the trial court, because they'd hit some sticky legal point and they needed to go up to the appellate court, have that decided, and then come back down to the trial court and finish the case out. So when it went up to the appellate court, the court goes through Georgia case law and tries to lay out what is the duty to inspect for a dangerous condition. And decay is the dangerous condition that they mention the most often, and it's the ones that come up in the cases the most often that I've seen in Georgia. So what the court says about the duty to inspect is, when you've got a decaying tree, there's no duty to routinely inspect trees for non-visible rot. And we'll talk about that phrase too a little bit later. But the landowner has a duty to inspect trees that do have visible, apparent, and patent decay. Later on, I refer to this as the VAP standard. It is used in all the cases in Georgia: visible, apparent, and patent decay. Lawyers are not going to use one word when they can use three. And I looked up all three of these words, and they all really mean the same thing. They all just mean obvious. So if the landowner knew or reasonably should have known, that's that imputed knowledge, that the tree was, and this is a quote from the case, diseased, decayed, or otherwise constituted a dangerous condition, then the owner has a duty to remove that danger. So the duty is, who owns the duty? Well, the landowner, the tree owner. What is the duty? Well, the duty is, if you know or should have known that the tree is in a dangerous condition, then you have a duty to remove that danger. So the landowner's charged with knowledge of that danger if the layperson should have known that the tree was diseased. That should have known is the key here. Again, it goes back to reasonableness. The courts don't say that lay people need to have expert level knowledge in tree care. They don't say, yeah, you need the knowledge skill set of a certified arborist. They say you're a layperson. We know that it's reasonable. Your duty is what is reasonable for a reasonable layperson, not for an expert. So going back to, we're back on our elements. We just kind of fleshed out through duty, who has it, what it is. Now, breach of duty is the second element under negligence, and that's just, you just did something unreasonable. You did not act reasonably in those circumstances. This is, if it goes to a jury trial, then this is what the jury decides. If it goes to a non-jury trial or bench trial where there's no jury, but there's just a judge, then the judge will decide this. But if there's a jury, this is what the jury is deciding, whether those actions were reasonable. Causation is the third element in negligence. In law school, we spend 2 weeks on just this concept of proximate cause. You can go down so many rabbit holes on this. Really, it just means, proximate just means that there is a reasonably foreseeable, close enough relationship between the breach of duty and the harm that happened that you can say that this was foreseeable. This is proximate. It was not an unforeseen act of God. If this goes to a jury trial, the jury does not decide this. The judge decides this. This is a question of law, not a question of fact. So the judge will always be the decider of this, never the jury. This is just a pointy-headed legal concept, so they just keep it with the judge. So damages, as I said, it's got two meanings in the law. One is the actual harm that was incurred, and then the other meaning of damages is the money that's awarded. It's kind of strange why they use it for both. There are different kinds of damages. The ones that apply to tree law basically are going to be compensatory damages. That is your out-of-pocket expenses. That can be medical expenses if the tree harmed you. If it fell on your car, then it can be the repair bill for your car or for your house or whatever was damaged. It can also be missed time at work if you lost some income or had to use sick leave. It can be to make that up. It's your out-of-pocket expenses that you can tabulate up. And this is the kind of damages that flow in these neighbor tree law cases the most often. There are also statutory damages, but that just means that there is a specific law in that state, wherever you are, that gives specific damages for this specific situation. That's not going to come up in negligence cases. It's not going to come up in tree law cases, but it does exist. I didn't want to not mention it. And then punitive damages, these you'll see in the timber theft statute. Punitive damages these are the crazy ones that you hear about in the jury verdicts, awarding millions and bazillions of dollars. This is when the behavior is so reckless that it is just beyond the pale. It is egregiously reckless. It is beyond unreasonable. It is to punish someone, hence the name punitive damages. These are the big ones. Like you might get maybe 100,000 to repair your property, but if the tree owner acted just completely egregiously reckless, not negligently, not unreasonably, so far past negligent or reasonable, then they actually could be potentially, it's always available, that the court could award punitive damages. This is a boundary tree case in Georgia. I cover this in the 2.0 section too, but it's a good one. It's Willis versus Maloof. It was one of the first, this was the first time that the Georgia Appellate Court had to deal with a boundary tree liability issue. They'd not had boundary trees make it that far up in the court system to have to be decided at that level that it was actually reported. Well, what happened in this case is Willis and Maloof were neighbors. Maloof was injured. They had a boundary tree, and they both treated the tree as a boundary tree. The tree had a trunk cavity. It had fungus on the bark, but it also had green leaves when it fell and injured Maloof. Willis gardened around the tree trunk, didn't think it was dangerous. The court didn't know, it didn't have anything in place. It didn't have a mechanism in place to decide this. It had never been confronted with this. So it said, the closest situation is going to be the party wall rule. We're going to use that. Adjoining landowners each own the part of the tree that's on their side, but they both have a responsibility to not unreasonably harm the whole, especially since a tree is a living thing, and anything that you do on your side certainly can affect the entire whole tree. Well, that's the party rule too. Even without the living party, the walls aren't alive. It applies even more on living trees. So both owners have a duty to maintain the tree over time, whatever the tree needs for maintenance, and to take reasonable steps to guard against the tree becoming a hazard or a hazardous condition. Both owners are jointly liable for any harm done by the tree, is what the court said. It went through this. It's like, well, we don't know how to decide this. We're just going to say party wall rule. That's close enough. So you each own the part. You can't hurt the whole thing. You have a duty to maintain your part, but also to be reasonable and take care of the tree as a whole. And you're also, since you're responsible for the whole thing, you're also liable for the whole thing. Here they had expert testimony, but it did not establish that the property owners who were treated as lay people should have reasonably known that the tree was a problem. The owner's duty is only that of a reasonable layperson, not that of an expert. No knowledge is imputed to them. So expert knowledge of the inspection, care, and maintenance of trees, that's not pinned onto a reasonable layperson. They don't have that specialized training, just a reasonable amount. I don't know why this picture's in the way. So knowledge of the danger, if you have knowledge of you can have actual knowledge or constructive knowledge of the danger. And here, the court held that Willis did not have actual knowledge because he gardened around it and he didn't think that it was a problem. He didn't have constructive knowledge because nobody came up and told him that the tree is hazardous. He didn't have an arborist indicate anything was wrong. Even Maloof didn't think anything was wrong. And the tree did have green leaves when it fell. So the court said, well, there's no actual knowledge, there's no constructive knowledge of the danger, so there was no duty of care. So Maloof didn't recover any money damages in that situation. And the tree down at the bottom is not the actual tree, I don't think. Another Georgia case is Cornett versus AG. This is also quite a while ago. These are the old ones when this was starting in Georgia. Here, a tree fell on a neighbor's outbuilding. And again, I don't think this is actually the picture. The tree was partially dead. It was near the lot line, but it was not a boundary tree. It was owned by one owner. It was leaning visibly toward the neighbor. So the neighbor had gone over, knocked on the door, said, hey, your tree, it's near my property and it's leaning and I don't like that. So that is knowledge. The landowner's intention had been called to that tree. Later, it was determined that the tree failed and that failure was caused by high winds and visible rot that had been pointed out to the owner. In this case, the court said that the duties in rural and urban settings are different. And this became just a big pivotal case. The court said, ownership of trees in like a planted pine situation, that's going to be very different than when you're in an urban setting and your tree, if it falls or if it's hazardous, it could do a lot of damage to not only your property, but other people's property. So it said, these are going to be different duties. The owner, the person that owes the duty is still going to be the tree owner, but what they have to do, their duty is going to be a little different when it's in an urban setting. So the court said the urban setting duty is you've got to use reasonable care in inspecting trees to ensure safety. There's no duty in an urban setting to consistently and constantly check for non-visible rot. Non-visible rot can mean there's a lot of vines down at the base here and they're growing up the tree and, probably the bottom 4 feet of the trunk is covered. I don't have to pull those vines off and check the trunk. I don't have to do that. That's non-visible rot. The duty does exist when the owner has actual knowledge or this reasonably should have known knowledge, that imputed knowledge, that the tree was dangerous in some way. And the reasonably should have known, the imputed knowledge, and the actual knowledge is when there is obvious visible decay. And obvious is just another word for that visible, apparent, and patent, that VAP decay. So the decay is not obvious and it's not visible and it's not a patent and apparent if it's covered with vines or undergrowth. So again, the landowner does not have to pull the vines away or hack your way through the woods to get to this tree that is really in the midst of a lot of undergrowth. You don't have to do anything unreasonable, but you do have to just use a reasonable person's duty of inspection. You just have to notice things that a reasonable person would notice. So it's obvious visible decay. And in this case, when the tree fell on the outbuilding, the owner here, the court set the money damages as the difference in the market value of the structure before and after the damage. It didn't use replacement cost. And the case actually spends quite a while talking about what the measure of the damages should be. And they ended up, this is honestly kind of a strange way to measure damages, but that's where they ended up on that one. Is there a question?
Yeah, there was another question of clarification. To be reasonable in maintaining a tree as a homeowner? Do they need to contract an arborist to inspect and maintain versus they do what they think is enough? And then is it reasonable to assume a professional arborist is needed to maintain trees, not just a homeowner?
That's a really good question. The courts have never, I've read all the cases in Georgia that I could find on tree law, and they have never mentioned a duty to have arborists under contract or to come on any kind of an interval. Really, the cases have all been aimed at what the landowner's duty is, and they do specify that they just have the knowledge of a layperson. They don't have to have arborist knowledge. That's not imputed to them. They don't need that skill set. Just what a reasonable homeowner, a reasonable person would do. Like if you're driving up your driveway and you see huge, obvious, visible decay, that then kicks in right here. If you can see my cursor in that second bullet point there, that will give rise to the duty that you now have actual knowledge of. There's a problem with that tree. That's obvious decay. And so that will bring up your duty to call an arborist or to investigate farther and to get an expert opinion. And so it's not, it's a really good question. It's a good thought that is there a duty to actually have an arborist under contract or coming at intervals? And there's not. It'd be great if there were, but there's not. But if the owner notices obvious visible decay or some other obvious reasonable condition that should have been noticed, then that does give rise to the duty to get an expert out there to assess it farther and find it and immediately mitigate it. Did that cover both questions? I kind of forgot the second question.
I think you covered that. There is one other question though, since I already have you paused. In Cornet versus a G, I think I'm saying that right. Any relevance as to whether the neighbor that knocked on the tree owner's property has quote unquote proof of contact, i.e. verbal? Should a homeowner that is concerned go through the process of having proof?
The court did not go through what the proof was. I think it was the neighbor just knocking on the door. And so when they got to trial, that neighbor could just testify, yeah, I knocked on his door and I told him you need to take care of your tree. And that's good enough. And to be extra careful in a hypothetical situation, so I don't give legal advice, it would be best if you sent a certified letter to the neighbor and enclosed a written opinion from a certified arborist that gives an opinion that the tree is dangerous or hazardous in some way, and maybe make some mitigation suggestions or next step suggestions. That can go to the neighbor by certified mail. If you are on good terms with that neighbor, another step to take is that person will then send that letter to their insurance company. You, and when I say you, I mean the homeowner, can also send it to your own insurance company. That's really what happens most. If you don't feel comfortable knocking on the door, and then yeah, that gets into, now I've got to testify that I knocked on the door and I've got to prove it. The easiest way to not have to prove it later is just to do it in writing and send it certified.
We have one more question coming in. If that person hires an arborist to come out and take a look and they assess the risk but don't give specific direction to take down the tree, does the duty shift to the arborist?
Well, it depends on what happens. Is that assuming that the tree then falls or becomes a problem? I mean, we got to make up more facts. Like what happened? And
They
how
say
soon after it, how soon after the opinion did the tree fall? Was there a big weather event? Were limitations given in the arborist's written opinion? There's a lot of facts missing on that one.
The questioner would like to assume that yes, the tree does fall.
Okay. So can you go back through it again? Remind me?
Sure, yeah. So if the person hires an arborist to come out and take a look and they assess the risk but don't give specific direction to remove the tree, does the duty shift to the arborist if the tree in question fails?
Well, best case scenario, the arborist in the written opinion has put a good disclaimer in there that points out that trees are living things and their conditions change constantly. We can't always predict what happens, and that every day a tree is alive, it's a different tree. And that disclaimer should protect the arborist. If the arborist, the duty would shift in a way that could end up as a lawsuit against the arborist if the arborist did not protect himself or herself in that letter, just by saying, oh, I'm sure the tree's fine, you don't need to do anything, but arborists wouldn't do that in writing.
Okay, we're going to take one more question. I have one more, and then we're going to let Lee continue on with the presentation. And then if other people have questions, we can take them perhaps further along in the presentation, just so that Lee has time to get through all of the slides. So the last question I have right now is, historically, do you see that judges/courts call in arborist opinion? Meaning, me as an arborist sees a large hollow section, less than 50% in a live oak, and know that it can be perfectly fine, but the layperson or even non-trained makes an argument in court that the tree was dead because of hollow status.
When there is an expert involved, and that would be a certified arborist, would be the expert involved in this, that expert's opinion is given in, a layperson would not be able to give an expert opinion in court. It just wouldn't happen because they're not qualified to. So only the expert would be qualified to give an opinion about the health of that tree. So it wouldn't become it was healthy, no, it wasn't, unless you had two experts battling. One says it's healthy, one says it's not, and then that becomes the battle of the experts, and then that is decided by the judge or the jury, which one seems more believable and more reasonable. Okay. Okay. This is the last case that we're going through. After this, we switch into the timber theft statutes. So I guess I'll just pause for a second and see. We're okay on time, so I'll pause and see if there's any other case related questions before we move on to the timber theft statutes, and then there's just a summary. So we're getting close to the end.
The only other question, it was another clarification about the use of hazard versus risk. In the current ISA tree risk assessment standards and training, use of the word hazard is said to be wrong versus risk or level of risk. Also, do not use the word danger, but again, use risk and levels of risk. In legal cases, hazard and danger are terms usually used. So what do you recommend as terms that we use?
I would follow the arborist guidelines. You are going to be acting as an arborist and do what Jesse just read there about use the word risk, don't use the other words. Follow those guidelines and use that in your speech and put that in your written reports. Okay, so all right. I will move on to the timber theft statutes in Georgia. Georgia is serious about timber theft. They are serious about it. They have huge penalties. This is one of the two timber theft statutes in Georgia. The most recent change to it was in 2022. So what happens is when someone cuts and carries away timber, the way that damages or the money that is going to be paid is measured it's triple the fair market value of trees cut as they stood. So triple the fair market value of what was stolen, then triple the diminished fair market value of any of the leaf trees that were harmed, then all the costs of reasonable reforestation activities to make the landowner whole again after the theft, and attorney fees and expenses of litigation. But it gets better when the property lines are really clearly and accurately marked. Then the law will presume that the defendant or the thief was a willful trespasser. So now the landowner can get punitive damages against the timber thief. Punitive damages are those huge big ones that juries go crazy on, and they are intended to punish that person and serve as a warning to future thieves, timber thieves. So Georgia is really serious about it. It's triple fair market value of what was taken, triple the diminished value of the harm trees, and then all the reforestation, and then all the litigation, and then punitive damages. It's one of the strongest timber theft statutes. It's really good one. This is a more recent one. This is added to the timber law statutes. It's this is a simplified version because the statute as it's written is pretty hard to make your way through. It's not written real well. I think it's all 4 sentences, and one sentence is like all of it. So this simplified version is that a timber thief is also going to owe if there is someone or something like a corporation or a real estate investment trust that holds an interest in that timberland as security for debt, and other people bought into that interest, whether the landowner knew it or not, then the timber thief also has to pay those people for the value of the trees up to the amount that the land is securing debt for, plus interest, and plus those people's attorney's fees. And any of the damaged timber that's left in place, then the owner can use it for firewood or farm use, but the thief is still going to have to reimburse them for triple the diminished fair market value of that damaged timber. So Georgia is very strong on timber thieves. We've gotten to the summary now. Tree owners can be sued when there's damage or harm from a tree. They can be sued in both nuisance and negligence. Negligence is overwhelmingly more common. Lawyers know it much better. It's kind of an easy thing. It's very common. Duty of care is owed by the tree owner. It's different when you've got a rural setting and an urban setting. Urban owners do have a duty to inspect to make sure that the trees are safe from visible, apparent, and patent decay, but they don't have a duty to consistently and constantly check for non-visible rot. They don't have to pull the underbrush away. They don't have to pull the vines away. They don't have to set up an inspection plan. They don't have to be on an inspection schedule. They just have to, when they go about their reasonable activities on their own property, well, they just need to look around and kind of inspect the trees. It's a low-level inspection. It's not like an arborist inspection. It's just do what a reasonable person would do that has trees on their land. And you know that trees they're big, heavy things. So you know that you got to look at them occasionally and see how they're doing. Rural owners don't have to inspect every tree because we're talking about like planted pines or large pieces of property where there's no or very little possibility of damage to neighbors' structures or a car or a road. They don't have to inspect every tree, but they have to take affirmative steps if they have actual knowledge. And of course, urban owners have to, if they have actual knowledge, like they see this huge decay, VAP decay, huge wound in a tree, they now have that extra duty to call in an expert, to call an arborist, and to get on a mitigation plan and to figure this out and to mitigate the hazard. So overall, in summary, the duty under negligence in tree law is to act reasonably. To act reasonably means to mitigate the hazard if you have knowledge of it. And that knowledge can be actual knowledge that a landowner has, or it can be constructive knowledge if that landowner really should have known. So if you know or you should have known, you got to act on it. So the takeaways that I hope you get from this is that there are 2 causes of actions. Both can be used in tree law cases. Negligence much more common. That there is the standard of care is different in urban versus rural areas, and I go into that much more in much more detail in the 2.0 Trees in the Law. I kind of go through the cases of how that develops and when they start comparing and contrasting urban and rural and why they put that in place. We also went through duty of care. Who owes what? Well, we know it's the owner of the tree. Well, who owns the tree? Depends on where it is. Is it a boundary tree, a non-boundary tree? Non-boundary trees are easier because you know who owns them, but then you have encroachment issues and other issues like that with roots and branches. And then with boundary trees, you have the different states do it different ways. So there's no clear answer, there's no clear guidance. You don't know definitely what's going to happen. I get a lot of questions about, well, if it's a boundary tree and it's this, well, how does Georgia do it? They haven't addressed it enough for us to really have guidance, is unfortunately the answer. And in some cases, they have explicitly declined to decide certain things, like the definition of what is urban and what's the definition of rural. They stay away from that kind of stuff, and they're just going to kind of let common sense do it. Also, we went through some Georgia case law and some of the early cases, Willis versus AG and Cornett, and also the 2 timber theft statutes in Georgia. So I hope it increased overall your knowledge of tree law issues and how tree law really is dealt with most often in Georgia, and how to either protect yourself or to tell your clients how to protect themselves. And so I hope it helped.
Haley, so we did get that question in the chat about what does Georgia say about boundary trees if a tree eventually grows into a boundary tree? What is the law in Georgia, and do you know about South Carolina either? Because this person is on the border in Augusta.
I don't know about South Carolina. In Georgia, I know specifically that they haven't decided it. It hasn't come up. If it's come up, it hasn't made its way up through the court system. Cases have to get to a certain level. They have to go up a couple of different stages through a couple of appeals before they're even reported. And people like me can find them online, or they show up in books, or they show up as published cases. Other than that, they just kind of, it happens at a very local level, and there's no way really, you can't research it, you can't find out decisions at that very low level. So nothing's made it up that high that I know of. Georgia has not decided it.
I have another question here. It says, I have seen many situations involving a tree falling and hitting the neighbor's property. Is my understanding that each property owner is to clean up the debris on their respective properties. Is there a law to reference this? And if so, where can I find it? If it is not an act of God and their belief of it being negligence, should the tree owner take care of it at all?
Okay, that was a lot of multi-parts.
I can break it.
Well, the first part
you want.
I remember
so
is
yes,
it falls and who has to clean it up? Yes, it's my understanding, and this is not legal advice because I have not looked into it myself, but this is my understanding that yes, both property owners have to clean up what's on their side. And it, what was the second part?
So that was, if there was a law to reference.
Oh, no, there, where did there's not a specific law on it. I'm thinking I saw it in an insurance related context that I can't recall, but it doesn't, there's no law to go to.
And if it's not an act of God and there's belief that it was negligence, should the tree owner take care of it?
Yes, but the question is getting that person to do that.
Right.
That's where the issue comes in, is that the tree owner won't take care of it or doesn't think that it's their responsibility.
Okay. Next question is, can you cover if a non-boundary tree's roots cross the property line and does or does not cause damage?
So you have a non-boundary tree. It's entirely on one parcel. The roots cross over to the neighbor and lift up a driveway.
They didn't specify any.
Okay. So it does damage. And then what is the question? What's the answer? How do you solve that? Funny, I just had 2 calls on that this week. Ideally, you talk to the neighbor and you come up with a solution. When that doesn't work, and that doesn't always work, the person who is being encroached upon should call a certified arborist and get a written opinion that It's the roots that are doing the damage, and come up with a mitigation plan of how do we stop the, I'm just using roots as an example. How do we stop the roots from doing this? Can we put something in place? Should we cut them? What can we do? And then an estimate or a prediction of how much that's going to hurt the tree as a whole. Get all that in writing, send that to the neighbor, certified mail, send it to their insurance company if you can, send it to your insurance company, and consult an attorney if you can't work it out with your neighbor, unfortunately.
The next question is, any guidance on derelict urban property, i.e. removing English ivy, etc.? Is it still trespass?
It sounds like, without a lot of facts, it sounds like the assumption is that you just go onto a derelict urban property that you don't own and you start clearing it. Yeah, technically it's trespass, but you're conferring a benefit. But if the owner doesn't see it as a benefit, that could kind of be a problem. Why not contact the owner? Why not? I don't know. I wouldn't advise that you do that, because what if you go onto that property and you get hurt? You're trespassing and you went onto it. I don't know if it's like an adjacent property to yours and you have to go on there to control invasive vines because they're coming onto your property. That can be a whole separate thing that I would recommend getting an attorney for, because you can get some help from your neighbor to do that. I've seen that happen, but it comes about as a result of an agreement rather than pointing to some law. But some cities do have invasive statutes or ordinances that will address, like in code enforcement, sometimes they'll slip it in and call it a not a derelict property, but if it becomes, I hate to use the word hazardous, but I have seen ordinances in local municipalities that do address if a property becomes just abandoned and it becomes a hazard and the vines are creeping on. So it depends on where you're at and what laws are in your area too. So that is such a complicated area that I would definitely recommend getting an attorney to deal with that.
This question says, I'm the county arborist and get calls all the time about private tree complaints and liabilities. Because I work as a county employee, I always refer to consult with a private arborist or attorney. As the arborist, I am not like an extension agent, but rather for the responsibility of county trees and tree canopy plan reviews for development requirements. Is this the correct action for me to remove myself and refer for my own sake as well as the county's?
Is that from Kay?
No.
Oh, okay. Can I get in touch with that person directly and we address that off screen? That's a complicated thing. That's dealing with county liability. I don't want to start giving legal advice, but I am happy to talk to that person, through email or phone call.
Yes, they said yes. I'll connect the two of you after the meeting. And that's right now all of the questions that I have. I'm going to put out a last call for any kind of questions that you may have for Lee. We do have about 5 minutes remaining. 4 minutes remaining. I did put the link for the form to fill out for the CEUs in the chat box. So if you will go to the chat, you will see that there. Fill that out and we will make sure that you get your CEUs for this event. Any more questions?
I'll stop sharing. And I don't know how to make you the host again.
You don't have to do that. I don't need to host anything.
Okay.
Let's see. Rachel has one in the chat that
Jesse?
says, yes.
I was going to say before Lee logs off, you do need host back just to make sure it doesn't end on everybody before CEUs. Sorry.
Okay, I'll take control. Let's see. There was one question in the chat that says, why send arborist report to insurance company if there is a risk the tree will fall in high winds? insurance companies will not pay for preemptive actions.
I missed like the first 3 or 4 words of that, the first couple words.
It says, why send arborist report to insurance company?
Okay. So you've got an arborist came out and gave you a written opinion that your neighbor's tree is hazardous. You could send that to your own insurance company, not to get them to pay for it preemptively, but just as documentation for if something happens later on, you can point to it and say, hey, my neighbor had constructive knowledge. I sent this certified letter, they signed for it. They have this information that an arborist said that this tree is dangerous. They've got the knowledge. So they had the duty and they didn't fix it. So that establishes your elements for negligence. Sending it to your insurance company is just preemptive that you've got your ducks in a row and that you pointed out to the other person, you gave them knowledge. It establishes that imputed constructive knowledge element.
Well, if there are no further questions, Lee, if you don't mind staying on once everybody else leaves, so I can tell you how to turn it back over to me. But thank you everyone for joining us this evening. Thank you, Lee, so much for the information that you had to share. We really appreciate your time and effort putting into this. And everybody be on the lookout for the recording and for part 2. So thank you guys. Have a wonderful evening. I look forward to seeing you all soon.
Thank you, everyone.
Lee,